This is case number 26-27-OD, appearances counsel.
Courtney Lawrence on behalf of the people. Thank you, Honor. Taylor Cannon, on behalf of Ms. Reese, who is present and seated to my right.
And we are here for a pretrial. Is there any resolution in this matter?
There is, it's my understanding the defendant will be pleading guilty as charged.
Ms. Firavento?
That is correct, Your Honor, but the people will not oppose a request for a bond modification, or at least rehab pending such thing.
Is that part of the plea agreement?
The people will not oppose it.
That's part of the plea agreement?
That's part of the plea agreement, yes.
Ms. Lawrence?
That's correct.
All right, Ms. Reese, have you heard what the attorneys have said the resolution in this case is?
Yes, I have, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Are you sure?
Yes.
So it's my understanding that you'll be pleading guilty as charged operating while intoxicated. That is a misdemeanor with a fine of not more than $500 and or 93 days in jail, suspension or revocation of your driver's license, possible vehicle immobilization, and interlock during any probationary period. In exchange for that plea, the people will not oppose an immediate release to treatment pending sentencing. Now, I want to make sure that you understand that. So the plea agreement is they won't oppose it, not that you're going to get immediate release. Do you understand that?
Yes, Your Honor.
And if I decide that I'm not going to release you to treatment, you would not be able to withdraw your plea. Do you understand that?
Yes, Your Honor.
Knowing all that, then, do you still wish to proceed today?
Yes, Your Honor.
Are you sure about that?
Yes.
Will you please raise your right hand as best as you can? Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear that this testimony will be nothing but the truth, and yes.
All right. Back on December 30th of 25, were you on probation or parole?
Not to my knowledge.
You don't have any prior criminal history, am I correct on that?
No, Your Honor.
So you were not on probation, you were not on bond. Do you remember reading and signing the advice and rights form? It talked about your rights to an attorney and your rights to a trial.
Yes, Your Honor.
Did you understand those rights?
Yes.
Most importantly, do you understand that you have a right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No, Your Honor.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements that are not made part of the record?
No, Your Honor. No, Your Honor.
And Ms. Reese, to the allegation that on or about December 30th, 2025 in the city of Cadillac in Wexford County, how do you plead to count number 1 of operating while intoxicated?
I plead guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on December 30th, were you operating a motor vehicle?
Yes.
And prior to operating that motor vehicle, had you consumed alcohol?
Yes, I have.
How much had you had to drink?
I had 2 drinks. Your Honor.
What were you drinking?
Patron. Double Patron.
Was it mixed with anything or just straight up?
Lime and salt.
All right. And you had an accident, if I recall correctly, from arraignment, correct?
Yes.
And that was here in the city of Cadillac?
Yes.
Do counsel believe defendants provided the factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor. Yes, Your Honor. We ask for it.
The court finds the plea is knowing, voluntary, and accurate. Ms. Reese, I find you guilty of operating while intoxicated. Ms. Firavento, we do not have a substance use assessment, correct?
We do not, Your Honor.
Oh, I'm sorry, Ms. We haven't gotten there yet. Ms. Lawrence, are there chemical tests to support the plea at all?
There is, Your Honor, the parties are stipulating the use of PBT at .131.
131?
Yes.
Ms. Fearvental, you stipulate to using that?
Yes, Your Honor.
Now, do the parties believe the defendant has provided the factual basis and the court rules have been complied with?
Yes, Your Honor.
As does the court. Again, Ms. Reese, I find the plea is knowing, voluntary, and accurate. I find you guilty of operating while intoxicated. We will set this for sentencing for a substance use assessment. And that brings us to Ms. Fearvental, your bond motion.
Thank you, Your Honor. My client has taken responsibility here today. She would respectfully request the ability to be released to treatment once a bed is secured. Are going to talk to our social worker, and we're going to get on trying to get her some sort of bed locally. She acknowledges the situation could have been much worse than it actually was. There was a crash involved. She realizes that she is very lucky that she was not seriously injured or killed or someone else. She realizes too that she did not perform the best originally on the bond, and she realizes that her conduct was not appropriate there. She was 22 years old. This is her first encounter with the criminal justice system. She would respectfully request the ability to utilize the resources here so that she doesn't come back. She is young and she has a lot of potential for rehabilitation due to her young age and due to her relatively minor criminal history. The judge has certainly sent the message that needed to be sent, and she has had time to reflect in her jail cell on the seriousness of this situation. And she's ready to move forward and to address the issues that led her here so that she doesn't come back.
Thank you, Ms. Lawrence.
Thank you, Your Honor. As the people have said, we are not opposed to immediate release for treatment pending sentencing. I have spoken to defense counsel, made it clear that we would prefer that to be all lined up before the court releases the defendant versus just letting her go on a PR bond at this moment. So I will leave it up to the court's discretion. Thank you.
So Ms. Fearvental, I want to make sure I understand. She does not have a bed yet.
We do not have a bed lined up yet, Your Honor. I'm going to talk to our social worker and get one lined up as quickly as we can.
So the process hasn't been started yet?
Not to my knowledge, Your Honor. I did meet with my client yesterday. She is, my understanding, working on trying to get connected with CMH as well and those services. And we're working on getting everything coordinated on that end. It's still relatively early in that process.
She's been in jail for over a week now. And there's been no attempt to reach out for treatment or CMH during that week.
I believe she did put in a request for CMH at some point, and then I guess it wasn't followed up on. When I spoke with her yesterday, I told her to put in another request.
Okay.
Because it's my understanding that if they don't meet with you after so many days and then you don't re-up that request, then they just assume you don't want to meet anymore. But I might be incorrect on that. I'm not as familiar with the Wexford jail as with the Misaki jail.
All right. All right, Ms. Reese is currently in jail on a bond violation. She had been released previously. Her violation was that she failed to appear for an ETG on the 3rd of January and failed to appear for the drug test as ordered on the same date. The information that was submitted with the violation request indicates that Ms. Reese did not read the rules of enrollment and stated, "This is bullshit. I'm not giving up my pot." She's also talking to her boyfriend about purchasing $100 worth of alcohol for a party. I've not been presented with anything today indicating that she needs help, nor has there been steps taken yet to get her that help. So the court is going to deny the request today, but we can always bring it up at another time. Anything else for the record? Ms. Reese, you'll need to go with the deputy. This is case number 26-25-OD, appearances counsel.
Courtney Lawrence on behalf of the people.
Thank you, Your Honor. Taylor and Hannah Carvento on behalf of Ms. Crowley, who is present and seated to my right.
And we're here for a pretrial. Is there any resolution to this matter?
There is, Your Honor. It's my understanding that the defendant will be pleading guilty as charged.
Ms. Fiorvento?
That is correct, Your Honor.
Ms. Cowley, have you heard what the attorneys have said the resolution in this case is?
Yes,
And is that how you wish to resolve it?
yes,
Can you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
It's my understanding that you'll be pleading guilty as charged to operating while intoxicated. That is a misdemeanor punishable by a fine of not more than $500 and or 93 days in jail, revocation or suspension of your license, vehicle mobilization for not more than 180 days, and possible interlock during any probationary period. You understand those, the charge and the potential penalties?
Yes, I do.
Back on January 1st of this year, were you on probation or parole?
No, I was not.
Were you on bond in any file?
No,
Do you remember reading and signing the advice of rights form? It talked about your rights to an attorney and your rights to a trial.
yes,
Did you understand those rights?
yes, sir.
Most importantly, do you understand that you have a right to a jury trial, that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
Yes, I do.
Well, has anybody promised you anything in order to get you to plea today?
No,
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
yes,
Ms. Fiorvento?
Thank you, Your Honor. We did review an advice of rights form this morning as well, and Ms. Cowley signed it. If the court would like that.
I have one in the file.
All right, thank you.
Our counsel aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
Then Ms. Cowley, to the allegation that on or about January 1st, 2026 in the city of Cadillac in Wexford County, how do you plead to operating while intoxicated?
guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on January 1st, had you consumed some alcohol?
Yes, I have.
And did you operate a motor vehicle after consuming that alcohol?
Yes, I did.
And was that in the city of Cadillac?
Yes, it was.
Were you stopped by law enforcement?
I
Or-
was already stopped and then law enforcement came on the scene.
All right. Explain that to me.
I was at a snowbank.
Okay. All right. Not on purpose, I assume.
No.
All right. Ms. Lawrence, are there chemical tests to support the plea?
There was a blood draw. We do not have those results yet, which is why it's as charged, but there was a PBT and that came back to 2149.
Ms. Fiorvento, do you stipulate to use of the PBT?
We do, Your Honor.
Do counsel believe the defendants provided the factual basis in which to accept the plea and that the court rule has been complied with?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Cowley, I find you guilty of operating while intoxicated. Do we need to set this over for sentencing? I assume, substance
Your
use
Honor.
assessment. All right, so we will set it for sentencing, waiting a substance use assessment. Ms. Cowley, just a reminder that your bond conditions continue.
Okay,
And you can go out to the front window, you check in and get your next court date.
all right, thank you.
Thank you.
Judge.